residents will have to pay capital gains tax in India from the next financial year. This is in keeping with the similar amendments made to the India-Mauritius Treaty. Sapna Das is outside the Finance Ministry with the details. Sapna, what exactly is changing, and does this also mean that GAR could be rolled out by 2017 April?
Well, the plan here is to dovetail most of these policy announcements. First, coming back to the issue of India-Singapore Treaty, well, this is completely on expected lines. So this is more of a clarification that basically from April 1, 2017, the taxation under the treaty will become source-based, which means India gets a right to, tax capital gains. It won't be residence-based, it won't be Singapore-based, basically. So that's one clarity that's coming in. For this, no amendment will be required. It will be an automatic flow. That's what we understand. But what is under negotiation is the fact that watch for the transition period that will be given to Singapore under the under the new contours which are being worked out. That is something, that announcement may happen soon, and definitely it has to happen under any circumstances before 31st March. This is also because last year when Mauritius got amended, the provisions are almost co-terminus with the Mauritius Treaty. Hence, the source-based taxation, the switch over there, will not require any further changes. But what will require a change is, the treatment of the transition period. And if the transition period is given, and a high possibility that, yes, it could be again 2 years in line with the Mauritius Treaty, then the tax rates also will be lower by at least 50%, just the way it has been done for Mauritius. So this is what we can expect on the Singapore front. Coming to the issue of GAR, which you have raised specifically, well, here again, industry is asking for another deferment. But the signal from the government is that they are clearly looking at an April 2017 rollout. They are also indicating very clearly any further abeyance on GAR is not required. Also a bit of detailing on that front, that this question has been raised ample number of times as to what happens if there's a conflict between GAR, which is a domestic anti-abuse law, and the international tax treaty. So here the clarity is that if the limitation of benefit clause, which also works sometimes as an anti-abuse clause, is pretty clear in a DTA, that is where GAR will not have to override, because the treaty itself will be sufficient to take care of any anti-avoidance. GAR application may be limited to those tax treaties where the anti-abuse laws are not very clear or are on the softer side. Having said that, the third big aspect that the government is looking at, and this will be very important from the industry's point of view also, a major overhaul is underway as far as the mutually agreed procedure is concerned under DTAs. Here, detailed guidelines are expected in the next 5 to 6 months, and which will indicate basically that all tax disputes and resolutions under MAP will be made public.
Okay, Sapna, just hang in there as well. Let's understand this further. Dinesh Khanabar is joining in to help us understand the implications of this. Dinesh, you were with us analyzing the impact when the Mauritius Treaty was amended. What do you make of this? This was expected and is on expectation line from what the government had said. But what does this mean? Simplify this for us.
So, two things. First, of course, as Sapna mentioned, this is on expected lines. But there's one thing very critical which is missing in what she has been saying, which is with regard to the grandfathering. So one of the critical things about the India-Mauritius Treaty is that if investment has been made prior to 31st March 2016, or 31st March 2017, sorry, then whenever it is divested, even after 10 years, 20 years, whatever, the existing treaty will apply, and therefore the gains will be exempt from tax. And therefore, it is quite evident that Singapore will ask for a similar benefit, and that can happen only if the tax treaty is amended. And I haven't heard anything thus far as to whether that is happening or not. I'm sure it will happen, but that's a very, very critical part. Second is a very important point which Sapna made, which I think is quite critical, and I'm heartened to hear what she said, which is to say that where a treaty has got a limitation of benefit, as India-Mauritius Treaty has, as India-Singapore Treaty will have, then GAR will not apply. The general anti-avoidance provisions will not apply. And the reason I'm very, very heartened is that the interaction that has come from the government officials thus far is to say that even if you comply with limitation of benefit under the treaty, they have a right to apply GAR. And if they do that, it will be significant uncertainty. You cannot say that I'll subject you to a scrutiny on two separate counts, one under the treaty, and even if you qualify under the treaty, I will check up whether under domestic law you are subject to anti-abuse. So if the government is now coming out with it, which I think it ought to, that will be a very, very welcome step. All in all, the way I would react is this, to say that the government did a very welcome thing, putting months in advance before the sunset to say how will GAR and Mauritius Treaty interplay. And by putting behind the India-Singapore Treaty, I think the government is really cleaning up the way in which people can come to India. There will be a degree of clarity and there won't be any confusion at all.
Mr. Kanaba, a quick question here from Sapna from Delhi. Also, in terms of the mutually agreed procedure, a major overhaul is being thought about by the government on that front, which would also bring in more transparency to the system under DTAs. The system has also worked very well. Senior tax officials are indicating that very clearly. So basically, they're also saying that a lot of the matters will be put out in public domain. How important do you think this would be? Would this be happening for the first time under MAP? Would this also address concerns raised by foreign investors, under DTA, but also resorting to MAP to resolve tax disputes? Your comments?
Again, a very, very interesting development, a very radical development. One has to say, how does it get implemented in practice? The proposition really is that when the OECD came out with BEPS guidelines, the base erosion guidelines, at that time, one of the recommendation was that if the two sides cannot reach an agreement under mutual agreement procedure, then they should subject themselves to an international arbitration. India was one country which has opposed this and is not agreeable to international arbitration, because it is the view of India that taxation is a sovereign right and cannot be ceded in favor of an international arbitration. Now, if that has to sustain, it is important that matters which are tax treaty interpretation related are covered within an agreeable time frame under mutual agreement procedure. Today what happens is that while there has been considerable progress in the last 2.5 years on the matters resolved under MAP, there are still many old open matters. And the two sides normally just agree to disagree and the matters go on getting dragged. The moment you say that you're going to put out these issues in the public domain, two things happen. First, it brings about transparency in the entire situation, which is very, very welcome. People know really where is India headed to. And number two, there will be a quicker resolution of the disputes within an agreed time frame. Very, very welcome.
All right, Mr. Kanabar, we leave it at that. We'll get more analysis through the day and discuss this further on What's Hot and India Business Hour. But for now, remember, this is what we are understanding from our sources, and an announcement is likely very shortly. We'll take a very quick break on that note. On to the other side, a CNBC TV 18 exclusive, Idea Cellular could